So you're charged with harassment. You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes,
You have
Judge.
the right to have an attorney present. If you're not afforded one will be appointed to you.
Yes, Judge. The officer was conducting a follow-up investigation and spoke to the complainant. The complainant knew the defendant by name and sight as they were in a dating relationship for 2 years. The complainant stated they ended their relationship in 2023, but continued to be friends because they worked in the same building. The complainant stated she initiated contact with the defendant via cell phone. The defendant showed up at her location and talked. The defendant asked to hang out, but the complainant stated she was busy. The complainant left the location and got a call from the defendant, and the complainant told the defendant to leave her alone and hung up. The defendant called her 35 times and called her using a secondary number. The complainant blocked both numbers, and the complainant got approximately 100 calls from a no-caller ID number. The complainant answered, and the defendant told the complainant to unblock her, and the complainant hung up. The complainant arrived at her office and saw the defendant calling her and was knocking and attempted to open the door to her suite. The complainant was escorted to her vehicle, and the defendant contacted the complainant 39 times via his cell phone, 1 time via a secondary number, 6 times via email, and 100 plus times from a no-caller ID. The defendant spoke to the officer and admitted to calling the complainant 100 plus times.
Buckle up, guys. Today we're looking at how a situation that starts with emotions can quickly shift into legal territory. The defendant explains that they reached out repeatedly because they were worried, but the judge focuses on the impact, not the intention. When someone says stop, continued contact becomes a legal issue, not just a personal one. The courtroom atmosphere changes as the judge clarifies how boundaries are defined by law. Feelings may drive behavior, but consequences follow the actions. Here, the judge tries to make a defendant understand that responsibility starts when you recognize your effect on others. This moment becomes a lesson in how quickly small decisions can stack up into serious charges.
Phone number and his secondary number and sending emails because she blocked him.
Mr. Humphrey, I'm going to find that there's probable cause to go forward with your case. You're on bond for murder. You now picked up a harassment case. You're lucky to be out on bond. Now you picked up a new case. I mean, really. I'm ordering you as a condition of your bond not to have any contact with the complaining witness. I'm going to put a GPS monitor so I know you're not going anywhere near this person. I will protect my community at all costs. Do you understand, sir? You're not to consume alcohol, illegal drugs. I don't want you going within 1,000 feet of where she lives, where she works, no weapons. You know, life is really short. It would really suck to spend the next 50 years in a 6x9 box. There's so many fish in the sea. It's not worth it. You know what I mean? Really. Move on. Just life's way too short. Really. You have the ability to hire a lawyer, Mr. Humphrey. Or do you need a court-appointed lawyer? Okay. Just, I want my community safe, man. That's all I want. Please. You know, please. I have an application on file already. So I'm going to have you sign a release of Victoria. I'm going to have you meet with Fleisher for your bond conditions. I'll provide you a lawyer here momentarily. Just think before you act. Come on. You were charged with criminal mischief. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Your lawyer is here with you on Zoom so that you know you're not alone.
Yes, Judge. On June 24th, 2020.
Hold on.
Yes, Judge.
All right, guys. Now the scene shifts to the break-in incident that really raises the stakes. The defendant insists they only entered to retrieve something they believed was theirs, but the judge breaks down why that argument can't stand in court. Once you cross into property without permission, the context is no longer emotional. It's criminal. The judge carefully explains how the law views this. Ownership claims don't override trespassing and damage. What matters is the action taken, not the justification after. The courtroom gets quiet as the judge warns that crossing that line again could lead to far harsher consequences. This is where the lesson becomes clear. Respect legal boundaries, or the law will enforce them for you.
On June 24th, 2024, the officers were dispatched to a burglary at a warehouse in Harris County, Texas. The defendant and another unknown male were seen on a security camera approaching the warehouse in an SUV and gaining entry to the side of the building by pulling back two metal sheets that lead to two large holes on the wall. The complainant estimated the damages to be valued at approximately $800, and the complainant stated the defendant broke into the property to attempt to retrieve items that belonged to him. The complainant stated to have filed a civil lawsuit against the defendant for not paying rent.
Say it again?
The complainant filed a civil lawsuit against the defendant for not paying rent, and that the complainant was there to obtain property. Or the defendant.
Mr. Gibson, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Don't go back to this location. Do you understand? If you pick up a new case, if you go back to this location, I'm going to revoke your bond and put you in jail. No more PR bonds. Okay. Now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Cedillo. JP, have you filed an attorney of record?
No, Judge, it's brand new. I'll get that done today, Your Honor.
Please.
Judge, I know you found PC, but just can you indulge me and can I just hear how the how my client was identified? I did not hear that.
Surveillance video.
Yes, Judge.
Okay.
That's what they say.
I mean, is there any description that it was him, or did anyone say that it looked like my client or anything like that? Did the officer look at the surveillance footage?
Yes, the DIM states explicitly that the defendant is seen on security camera coming onto the property.
Okay. We'll take a
I
look
mean,
at
if you get the video, it shows something different, come back. I'm always ready to entertain anything at a later time, you know?
Of
Really.
course, Judge.
So,
Thank you.
but until that time, don't pick up a new case. Don't go back. All right. So Vic, you want to give me a date?
Yes, Judge, how is March 25 through the 27th?
Let me see, Judge.
Judge, was that state's bond conditions?
Yeah.
Okay.
Judge, March 25 will work.
Yes.
Okay, jurors. Okay, so for now, I'll have you sign a reset. We'll have you take a seat while we get your bond conditions. We'll have you sign it, and then you'll be free to go. Okay?
Thank you, Your Honor.
Mr. Caldwell, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle traveling 35 miles per hour in a 20-mile-per-hour zone on Pine Dust Lane. A traffic stop was initiated, and the officer made contact with the defendant, the driver of the vehicle, and the defendant was not wearing a seatbelt. The officer further observed an odor of marijuana and asked where the marijuana was located. The defendant stated the marijuana was located in the back seat. The defendant gave consent to search the vehicle, and the officer found a clear plastic sandwich bag with a green leafy substance in the back seat and a glass container with a green leafy substance. The total weight was 0.921 ounces.
Okay, Mr. Caldwell, I'm going to find that there's probable cause to go forward with your case. Have you looked to see if he has a license?
It's not eligible, Your Honor.
Okay, you're not allowed to drive. If you don't have a license, do not drive. Do you understand? If you go get a license, if you get insurance, come back to me. I'll take this restriction off. That's your only condition. Don't get in trouble and don't drive. Do you understand? I'm going to have you sign an affidavit, which is a promise you're making to me. That's the only condition, Mr. Caldwell. Don't drive. Now, you have a lawyer. Remain in contact with him. I'm going to waive your appearance. You don't have to waste your time coming to court, but you must stay in contact with him. If he tells me he can't get in contact with you, I will revoke your bond. Just don't pick him a new case and be good. All right? Come on. Thanks, Mr. Cole. Ms. Newton, you now stand charged with 2 more cases. You're charged with another theft case. You're also charged with failure to identify oneself to a peace officer. You are facing up to 6 months in jail and or a $2,000 fine. On both of those cases, we are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On January 17th, 2025, the officer was dispatched to JCPenney's regarding a theft or shoplifting. The officer made contact with the complainant, a loss prevention employee, who stated the defendant, Newton, and a co-defendant, Woods, entered the store, selected several items, put the items inside a personal bag, and exited the store, passing all points of sale without paying for the concealed items. The complainant stopped the defendants outside and escorted them back to the loss prevention office. While at the office, the defendant identified herself as Christiana Ray to the officer. An AFIS search came back to reveal the defendant's real name with an outstanding warrant out of Harris County, Texas. The total value for the items was $268.
She has a theft from December of 22, a theft from June of this year, of last year, and now 2 more cases. Was she on bond for either of these cases when she picked up the 2 new cases?
Let me see, Your Honor.
Okay. You are looking at Miss Newton here. Was she on bond for any of these cases, or were they all just in open status? It's 254, 8009.
Or it appears bond was made after the new cases. On the 19th, the new cases were picked up on the 17th.
In the court processing page, last name KOTUN, that's the original case, and there were multiple bonds posted on that one. A GOP and a surety, and then these other cases got picked up. So it's a third name.
On the 251, it appears she posted bond only one time on the 19th of this month. On the 243,
Judge, on the 243.
that's the one that was
the
in
GOP.
current status, right?
Yes, Judge.
Where are all those from?
So the theft, cause number 243 was a Dick's Sporting Good. The
So Dick's,
Dick's, and then 251 theft was a Sephora, and then the most recent theft was a JCPenney.
Miss Newton, Miss Williams, I'm going to find that there's probable cause to go forward with the case. I'm now putting a monitor on your ankle so I know where you are at all times, and you are forbidden from going to JCPenney, any JCPenney. You're forbidden from going to any Sephora. You're forbidden from going to any Dick's Sporting Goods. If you pick up a 5th case, I tell you now, your bond is going to skyrocket. Do you understand, ma'am? Would you like to apply for a court-appointed lawyer, ma'am? Okay. We're going to have you sign a reset with Victoria. After that, you'll get with Felicia for your bond conditions. Do not pick up a 5th case. I'm telling you now. I don't know what you're doing, but you pick up another case. You're also not to hang out with the other person, the co-defendant in this case as well. Do you understand? So can you reach out to the MAC for her, and then she'll have conditions with Felicia? Okay, please, ma'am. Morning, Mr. Price. Sir, you're charged with 2 cases. You're charged with assault of a family member. You're also charged with a garden variety assault. On both of those, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The complainant, Terrell, and the defendant were in a previous dating relationship. The defendant followed complainant Terrell into a bathroom of a bar and began to slap complainant Terrell multiple times in the face, struck complainant Terrell with a closed fist multiple times in the face, and grabbed complainant Terrell by the throat, but did not impede breath. The defendant would not allow the complainant to leave, and complainant Asher, friends with complainant Terrell, walked into the bathroom. The defendant struck complainant Asher in the face with a closed fist.
Who?
So complainant Terrell is the AFM and complainant Asher is the ABI.
Terrell, is that a?
That is a dating relationship.
Got it. Okay. Mr. Price, I'm going to find that there's probable cause to go forward on both of your cases, and I'm ordering you not to have contact with either person. Do you understand? On the family member case, I'm not seeing a protective order issued on Price. Can you see one?
I don't see one file of it, and,
Okay, I'm entering now what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Terrell as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat of harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Pierwood Drive house. Do you understand? If you violate this court order, the state can and will file a violation protective order against you. It's one of the worst cases you can pick up. So you're also not to have contact with the complaining witness in the assault case and not to be in possession of weapons as well. We're going to file these conditions. You'll need to sign it. Did you need a court-appointed lawyer today, Mr. Price? Okay. You can reach out to the MAC. I've got an application on file. I'm going to have you sign a receipt, Victoria. We'll have you take a seat in the jury box where we'll get all your bond conditions. You'll sign it, and then we'll provide your lawyer here momentarily, sir. Please. Mr. Randolph, you're charged with tampering with a government record. You're facing up to a year in jail and or a $4,000 fine on that one. You're also charged with possession of marijuana. On that one, you're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 13th, 2025, the officer observed the defendant's vehicle bearing a temporary buyer's tag with an expiration date of December 25th, 2024. The officer ran the expired buyer's tag through NCIC and observed the license plate to not be registered to any vehicle. A traffic stop was initiated and the officer made contact with the defendant, the driver of the vehicle, and the front seat passenger. The defendant admitted to having printed the buyer's tag himself and putting it on the back of the motor vehicle. The defendant stated he printed the buyer's tag at UPS or something. The officer observed a strong odor of marijuana, and the defendant admitted to smoking earlier that day. A PC search of the defendant's person and vehicle were conducted. The officer located a small plastic bag containing a green leafy substance known to be marijuana based on training experience in the defendant's front right pocket, and a clear plastic bag containing marijuana in the center console of the vehicle. The weight was 0.3 ounces.
All right. Mr. Randolph, I'm going to find that there's probable cause to go forward on both of your cases. You look up to see if he has
It's not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life, Mr. Randolph. You will be signing an affidavit with me today, promising me you're not going to drive. If I find that you do, it's not going to go well for you. Do you understand? If you want to drive, go get a license, get liability insurance. If you can show me that you have both of those things, I'll take this restriction off. But I'm going to tell you now, if I find that you do, it's really not going to go well for you, sir. Did you need a lawyer today, sir? Okay. See, show file. I need you to fill out an application for me. I can provide you a lawyer today. Above all else, in the short life that we have, do not drive. This is an affidavit that you're going to be promising me you're not going to drive. Do you understand? All right, come on. Ma'am, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On January 18th, 2025, the officer observed the vehicle failing to drive in a single lane on West Grand Parkway in Harris County, Texas. The defendant was swerving in and out of two lanes and came close to crashing into another vehicle in the next lane. A traffic stop was conducted, and the officer made contact with the defendant, the driver of the vehicle.
Here, we see the broader pattern that shapes how the judge responds. Multiple thefts from different stores show that this wasn't a single lapse in judgment. The court has to look at behavior trends, not isolated events. The judge emphasizes that repeating the same choices signals a path that can lead to even more serious legal trouble. To prevent the pattern from continuing, the judge orders GPS monitoring and bans entry to every store involved. This isn't just punishment. It's a structured attempt to break a cycle before it becomes irreversible. The message is clear. Change needs to happen now, before the consequences become much heavier.
In a moderate odor of an alcoholic beverage and slurred speech. The defendant could not provide ID or insurance, and the officer observed an open container of alcohol on the floorboard next to her feet. The defendant stated she had not consumed alcohol, and the officer observed slow movements and unsteadiness on her feet. Standard field sobriety tests were conducted, HGN 6 out of 6, walk and turn 8 out of 8, one leg stand 2 out of 4. The defendant was read the DIC and consented to breath. The results were 0.290 and 0.294.
So are you telling me that she had alcohol in the car while she's driving?
There was an open container on the floorboards.
Did you put any other indicators like it's cold or?
No, Your Honor.
Ms. Keys, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Do you understand, man? I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail, man. No more PR bonds. Have you run your license, Alex?
I'll run it right now, Your Honor.
Please. And any prior DWIs?
There are no priors, but there is a pending one out of Austin County, it appears.
She has a pending DWI in Austin County?
Yes, Judge.
I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason. You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, I can have a contempt hearing every single time you drive. It's an offense in and of itself, punishable by up to 6 months in jail and a $500 fine every single time. I am now going to put an ankle monitor on you so I know that you're not consuming, and I'm also giving you a curfew of 7 p.m. to 7 a.m. On your other ankle, you're going to get a GPS monitor. Stop. I don't want you to talk about the case. I can provide you a lawyer today, but if they're telling me that you have an open DWI and now you picked up another one, I have a big problem with that. I was going to provide you a lawyer today, ma'am, if you would like, a court-appointed lawyer. Did you want a court-appointed lawyer? I will provide you a lawyer today. Ms. Keys, if you have a problem with alcohol, I'm giving you the opportunity now to address it on your own. If you do not, I'm going to do it for you, and I promise you're not going to like the way that I do it. Do you understand, ma'am?
Yes.
I'm going to do everything in my power to protect my public at all costs. Every single day, someone dies from a DWI in our county. I need you to fill an application for me or you know what? Hold on a second. Maybe I have. Vic, I have an application on file already. So if you just want to appoint her a lawyer, I'm going to have you sign a receipt with Victoria. You will meet with Fleisher for your bond conditions. And after that, we'll have you take a seat while I find your lawyer.
I can.
I'm going to have you sign a reset. After that, you'll get with Felicia for your bond conditions. After that, I'll have you take a seat while I find your lawyer. Please.
No driving affidavit?
Oh, yeah, no driving affidavit. Right.
I spoke with her again. She said that she needed to reach out to her dad and brother to see a time that would work for him to come.
Where is the car?
The
Where?
car is at the property at,
Is it in the, like, apartment complexes have outlying lots. They have lots that are inside of a gate. You need a code to get in to get the car. She didn't say where the car is?
I know the address of where the car is. I don't know exactly what type of property it is.
Can we do an in run around this, Judge? If you'll allow exemption for me to do all the middle manning, I'll just go and pick up the vehicle. I'll get it. I'll talk to them and
Okay.
get it somewhere.
And you're an officer of the court. I trust you. Find out where the car is exactly so he knows exactly where to go get it. Hopefully it's not in a complicated place where he's going to have to talk to them because I don't want him to talk to them.
Of course, I will be communicating with them about anything from him, just for him to get it.
So let them know that he's not to talk to them. If he goes and tries to talk to them, I'm putting him in jail, right?
Yes, Judge.
Just to get the car, that's it. And
I
get the middleman, right? Yeah, of course you can. I mean, you're the go-between.
Yes, Judge.
Okay.
Okay,
Thank you, Your Honor.
for sure.
Will we need to redraft that? You can just finish on.
Let me see what it says. Hold on.
But technically, if I'm doing it, I guess it's still no contact.
So what I'm gonna do is I'm going to edit this to say this. It says, do we know what day he wants to go back?
I don't know, I'll have to sort all that. That's why I'm saying there's gonna be some contact about, is there a gate code? Where is it? When? So I need to,
Because he's got 3 days from the date of that letter, right? When was that letter?
I think it said until the 20th.
Okay, just remind me.
Okay, so I'm gonna put here, defendant has until 1:25 to go get his car from the above listed address. Defendant is not to have any contact with the complaining witnesses and no weapons as well. So he's going to be the middleman to figure out where that car is for you to get it, you get it, and you go.
Finally, the DWI discussion brings everything to a serious close. The judge reviews open container details, failed field tests, and past interactions with law enforcement. The tone becomes firm, reminding everyone that impaired driving isn't just about the driver. It puts the entire community at risk. The court issues curfews, monitoring, and a no-drive affidavit to prevent more dangerous decisions. These conditions are set not just to punish, but to protect. This moment highlights how the justice system steps in when someone's choices repeatedly put others in danger.
Don't dilly-dally, don't try to talk to them. If someone comes, just get it and go. Make sure you have everything with you. They're probably going to maybe want insurance. Don't bring an insurance card. You know, it's like when you go pick up your card at your car at like an impound lot, you need your insurance card. If you don't have insurance, they're not going to give it to you. Make sure you come with the keys, you've got your insurance card, everything so that you know. You understand?
Yes, sir.
Okay, all right. We'll have you sign this. So you know what you can and can't do.
Yes, sir.
All right, okay, good. Come up, sign it, we'll let you go.
Thank you.
Okay, and thank you,
Thank you for your patience.
JP. No, thank you. You're doing great. Sorry, Mr. Pons, I'm just,
The affidavit and that she said she didn't feel pain.
I don't know. All I know
No, I'm
is
telling
that,
you, that's why I'm up here challenging the PC on that one. There's an affidavit, a complaint that's provided.
There's an affidavit, because in the
hey,
DIMS,
this is on Corral? This is a new case, right?
It's a complaint, so it happened in October 2024.
How did it get an affidavit here so quick?
Because it's a complaint, the officer's affidavit on the complaint. He states that she stated she didn't feel any pain because she was fighting him.
I
As
thought-
well.
But you said that you did feel pain.
the complete DIM.
I wouldn't, or that's the problem, is the DIMS is maybe contradicting or inaccurate or different from the affidavit that I'm talking about. That the officer filed with the complaint.
So the complete DIMS reads, the complainant stated she did not feel pain at the time of the incident since she was fighting the defendant off of her, and that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So according to the full DIMS, the complainant didn't say she felt pain. She said that she didn't feel pain at the time of the incident because she was fighting the defendant off of her. And that's what the full DIMS states. And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
It could also be the exact, that what she said was, I was shaking and crying because I was fighting him. She's the one that says that.
I mean, I get it. Like at the time, you're in the stress of the excitement, so you're not feeling it. But then after,
That's not what she said though, or that's not what
Stress.
they're going on.
Your Honor, the key thing the officer observed were the bruises on the complainant's arm. He observed the bruising and then came to the conclusion based on that. And what she told him, she did say that the defendant squeezed her arm. And based on that, her crying, shaking, and the bruising, he came to the conclusion that she felt pain due to that being squeezed.
I mean, taken as a totality, is that not sufficient for probable cause purposes?
I don't know. You have a sworn document where she says one of the elements is missing. And then everything else that he's adding is not in that
To
document.
be more specific, she's saying she did not feel pain at the time of the incident since you were fighting. She didn't say she didn't ever feel pain. She said at the time since she was fighting the defendant off of her.
But the officer.
not in that.
asked- But the officer never asked, hey, do you feel pain? Why
And
wouldn't
of
you
course, the officer
ask?
never asked. He tended to conclude it based on totality.
Get it, but I don't know. I mean, I need to look up case law. I'm not sure. I don't know if that's enough. Because I mean, it's such a low standard for probable cause purposes, you know? I mean, I get that you're saying that it's not allegedly pain as an element, but taken as a totality.
I guess you're saying
No.
taking as a totality. I'm saying that's a lot of speculation about stuff that's not in the DIMS or in the affidavit. Like you're making all these connections state.
I'm making the officer made the connection. He said in the DIMS, due to my training experience, I know being grabbed and bruises being left on your body causes pain. So
Right.
he made that
You
connection.
don't operate on hunches.
Right, and she's also stated that I was fighting him, so that could be because of her
I mean,
fighting.
here's the deal, like if I find no PC, right, they may just re-indict it though.
That's fine.
You know?
That's their.
Kelsey,
Yes, sir.
did you see what's going on? So in this case here, the officer never asks her, do you feel pain? He assumes she does just because of bruising on her arm. And because I guess they're in the stress of the excitement. So at the time she doesn't feel pain, but after a while, he assumes that she feels pain because of bruising on her arm.
And on body worn camera, he never says, we don't know.
But well, I mean, this is a probable cause hearing. We haven't seen it. So he wants me to find no PC. If I do though, right.
Well, if there are visible injuries, we can go from there.
But he's saying that, you know, I mean, if it were like blood, like some kind of tearing of the skin, that's one thing. But bruising, is it possible to get a bruise without feeling pain?
Yeah, I do
You
it
know-
all the time. If you fall downstairs and you're embarrassed more than in pain, you might be crying or shaking because you're embarrassed or excited, but it's not because of you injuring yourself down the stairs.
But Your Honor, that also ignores that she did say the squeeze itself. He mentioning a fall, but in this case, we do have a specific statement about a squeeze.
She doesn't say that she's in pain because of the squeeze.
So
I
if we
mean-
play it out in front of a jury, you would always have that statement saying at the time she didn't feel pain. Whatever you said contradicting that, that's fine, but it would not take away that statement that eliminates an element.
That's what I'm saying.
So maybe a grand jury might find it different, but based on that DIMS, they have someone saying, I didn't feel pain. I think that's kind of like,
And Your Honor, I will say at the time, we don't have the full OR, so if you want to find no PC, we can revisit it. If we want to re-indict it, we can.
Okay, all right, I'll find no PC.